Hello everyone, welcome to Skyrise Academy. If you haven't yet subscribed to the channel, do subscribe it to be notified regarding important videos which will aid you in your UPSC preparation. So today we are going to study a very interesting topic which is based on the Hindu newspaper editorial of the 30th June 2021, that is today, right? So the heading of the editorial is App Judicial Reminder in the Era of Over-Criminalization. So, sounds interesting, right? So, here is the news. Recently, in the Delhi High Court, dated I guess in 15th or 16th June, this news was there in the all other newspapers that the Delhi High Court has had granted the regular bail to the JNU students in the case of Northeast Delhi riots. You must be well aware about it. The case name is Asif Iqbal Tanha versus State of NCT of Delhi 2021. So this case was about booking the students of JNU on and tagging them as terrorists, which the court criticized because when they are charged under the Terrorist Act, they are not granted bail. It is a non-bailable offense. So that's why the police misuses the act in this way by charging the conventional offenses under the Terrorist Act. So this is what the Delhi High Court has recently criticized, and this editorial is all about. And it is very important from the UPSC mains point of view and also is important from the law optional point of view. So here are the High Court's observations. Firstly, the definition of Terrorist Act, which is given under the section 15 of the UAPA Act, is very wide and somewhat vague also. We will discuss the definition further. The phrase Terrorist Act cannot be permitted to be casually used for any criminal act. The Terrorist Act are very grave. So it shouldn't be used for just the conventional offenses, right? Further, the word terrorism and terror has not been defined in UAPA. Intention and purpose of the Parliament and amending it, the Act, is to bring the terrorist activity within its scope, but it is concerned with the defense of India and not just, the normal riot case or something. So it is misused gravely by the state machinery. And what's its impact? It defeats the purpose of the act, right? And further encourages its misuse. So let's see the origin. The Terrorist Act were brought within the purview of this Unlawful Activities Prevention Act by an amendment in 2004 in the backdrop of repealing of POTA. Before POTA, we had TATA, which was repealed in 1995. That stands for Terrorist and Disruptive Activities Prevention Act, TADA Act. Here we have a very famous case of the actor Sanjay Dutt under the TADA Act. So let's see the section 15 of UAPA. So it defines whoever does any act with the intent to threaten the unity, integrity, sovereignty of India. So see, it is connected with the defense of India. How do they threaten it? By the use of explosives, which can cause the death or damage or property or disruption of essential supplies or destruction of any property of India or in our country or in a foreign country, which is intended for use for the defense of India. Or it uses the criminal force to cause death of any public functionary, or it's related to kidnapping. So here when they use this by any other means, so this makes it very vague and widens its scope. And because of this vague definition, it is being misused greatly by the state machinery. So let us now see this was all about this particular case. Now let's look deeper into it and study some more case laws, which will be very helpful in our exams, right? So, criminal justice system. What comes to your mind when you read this? It consists of the police and the judiciary, right? That makes our Indian criminal, and of course the reformative prisms, and this makes the Indian Indian criminal system. Here there is a famous quote mentioned in the article which you can learn and write in your essay or means paper. It will help you fetch marks if you could remember. So the criminal justice system is an instrument of state and is a key index of the state of democracy. Some believe that it should only be used as a last resort and only in most grave offenses. Criminal law reflects the idea of power rather than justice. This is again believed by some who believe that the punishments, should be avoided, should be given in the gravest of the offenses. So punishments, there are various theories on it. There are 5 theories. So for India follows the retributive and rehabilitative theory of punishment. Retribution is if like eye for an eye. Mahatma Gandhi was totally against it because he quoted an eye for an eye will make the whole world blind. But our country believes that in the gravest of the offenses, retribution is necessary for justice. Then we even have rehabilitation in the Indian criminal system because we give every opportunity for their prison reforms and we help the prisoners to develop themselves by them engaging in various activities. Some have even written books, some have cleared the exams, some are engaged in the other activities which helps them in their rehabilitation, right? So what is the issue? Issue is the misuse of this act, that is the TADA Act, which is obviously repealed. So now the current issue is the UAPA, Unlawful Activities Prevention Act 1967, along with its various amendments. That is the grave issue here. So examples of misuse. So you can see in the period of 2015 to 19, around 8,000 people were arrested, but only 150 were convicted by the trial courts. And again, these cases, go under the appeals in the High Court, and there is hardly any conviction, just 1% amongst them. Till 1994, though 67,000 people were detained, just around 700 were convicted. So you can see the conviction rate. It is so low. Here the example is, we have a case law, very famous case law, Kartar Singh versus State of Punjab. It relates to the Supreme Court had here, scolded the prosecution that it was unjustified to invoke the provisions of TADA. So with the motive of depriving him from getting bail. See, that is the main reason why the offences are booked under TADA, so that the accused person is unable to get bail. This reflects the misuse of or abuse of the act by the police. The court also held in this particular case that the mere disturbance of public order cannot be considered as a terrorist act. Terrorist act is completely different from the normal conventional offenses, and everyone knows what a terrorist act is. So this is just the coloring and the malicious motive under which the normal criminals are booked under the terrorist acts and are labeled as terrorist. So let's now see the definition of terrorism. This Delhi High Court took the support of the Supreme Court's previous cases to define the terrorism again and to direct the Delhi police to keep in mind while booking anyone under these acts. So the first case law is Hitendra Vishnu Thakur versus the state of Maharashtra. So terrorism relates to the lawlessness and the cult of violence. It doesn't merely cause disturbance of law and order of the public, but it should travel beyond the capacity of ordinary law enforcement agencies to tackle under the ordinary penal law. So what it says is, when it is impossible for the normal law, penal law, which is the Indian Penal Code, then only such offences should be booked under the Terrorist Acts, that is UAPA. It states a very good quote, again this you can use in your answers. Every terrorist may be a criminal, but every criminal cannot be given a label of terrorist, only to set in motion more stringent provisions of Tata. So well said by the Supreme Court, right? So you can again use this in your answers. So in the terrorism, its effect is not just physical or mental, but it has psychological effect on the society as a whole. For example, the bomb blast, Mumbai bomb blast, which is the next case, Mehmoon case of 2013. We will discuss it again. So that is the psychological effect on the society. Even the parliament attack of 2002, that is a terrorist act. You know, the Rajiv Gandhi assassination case, the court held that it was not a terrorist act. We will see that how. So the main objective is to overthrow the government or to disturb the harmony of the society or to terrorize people. Right? In the Yaqub Abdul Mehmoon versus state of Maharashtra, the accused, recently appealed to the Supreme Court to squash his death penalty, which the court obviously refused, and held that what happened in Mumbai in the year 1993, that was a terrorist act. It included 12 bomb blasts, serial bomb blasts, and it was held because they say that it was the retribution against the demolition of the Babri Masjid in the year 1992. So the court observed that the terrorist act can range from actual assassinations, kidnapping, hijacking, car bombs, and use of chemical, biological or nuclear weapons, etc. So by this interpretation, even the protest against the Citizenship Amendment Act in few localities in Delhi cannot be termed as a terrorist act. So here is the Rajiv Gandhi case, state of Tamil Nadu versus Nalini and others, 1999. Here the Supreme Court has observed that none of the accused intended to overthrow the government or strike terror. So these are the main ingredients for an act to be classified as a terrorist act. And therefore the killing of our former Prime Minister was not held as a terrorist act under Section 3 of TADA. We have another case here, Ram Manohar Lodhia versus State of Bihar, 1966. Here the Supreme Court explained in detail the distinction between the law and order, public order and security of the state. Law and order represents the largest circle within which there is the next circle representing the public order, and the smallest circle, the innermost circle, is the security of the state. So when any act affects the law and order but not the public order, similarly an act may adversely affect the public order but not the security of the state. In most UAPA cases, the police has failed to understand this distinction. So UAPA is attracted only when the innermost circle is affected, that is the security of the state. So this is very important observation. You can even draw this concentric circles in your answer writing to make it more pictorial, and it helps fetching more marks, right? So last case on the definition of terrorism is UPCL versus Union of India 2003. In this case, the constitutionality of POTA was challenged. Supreme Court highlighted the another dimension of the Terrorist Act and included under it amongst the other things, that is the raising of the constitutional principles, tearing apart of the secular fabric, and promotion of prejudice and bigotry. So these acts were also included under the Terrorist Act under this case. These were the case laws on terrorism. Now let's see what's the position globally. So there is no consensus on its definition. There are more than 100 definitions of terrorism available, but no universal definition is available, neither at the India level nor at the international level. UNGA has given this task to a committee, but it has since last 50 years or so there has been no consensus. Accordingly, our national legislations have not defined the terror and terrorism. So what is the way forward? The first principle of criminal law, that is the criminal provisions, are to be given narrowest possible meaning, must be applied in letter and spirit by the state machinery. Also, to ensure that the person should not be roped into a penal provision, more stringent a penal provision, the more strictly it must be used, right? So the terrorist acts should not be used very randomly and should be used only when it is absolute necessity. So the definition of terrorist act is very wide, so it should not be casually applied to the conventional crimes that should be taken care of by the police. Lastly, no law can really end the problem of terrorism. So how can we stop it? The main reason why terrorism flourishes is because the people have been subjected to injustices. For example, the Kashmir issue. There people claim that there have been so much injustice, and so they find that terrorism path right from their perspective. Same is with the Naxalites, right? So the key is to remove the injustice to combat terrorism. Creation of truly just and non-oppressive society will be far more effective in tackling this problem. So this is the wholesome, idea to have that truly just society and tackle smallest of the injustice so that we don't create terrorists in our society. So here the topic ends. If you have any queries, you can, reach out to us in the comments section. Don't forget to like the video and share it amongst your friends. And this is very important from the exam point of view. So do make notes and remember all the case laws. Thank you.